lays it out. Talks about how the federal government made decisions in the 1930s and 40s when they got into the business of public housing that was segregated. Talked about the Federal Housing Administration in the post-World War II years, and the time when America began to create its suburbs, and that whole suburbanization process underwritten, as you know, by federal policies that were segregated. The refusal of the FHA to subsidize mortgages, or rather to give mortgage insurance in racially heterogeneous areas. Even before that, the massive blanketing of communities with restrictive covenants outlawed by the Supreme Court in Shelley versus Kramer in 1948. When I bought a house here in Ann Arbor, I bought a house that I actually loved. It's still one of my favorite houses I've ever lived in. It's on Brooklyn Avenue in a neighborhood very close to the neighborhood, to the law school where I could walk. I happened to get all of the deeds that had run with the house. Being a civil rights lawyer, I was interested in looking at them. And sure enough, there with the deeds, as I searched back, was a restrictive covenant on the house. You know, the house could not be sold to Negroes and Mexicans, and I think Jews also. Of course, it was no longer effective, but that was a community that hadn't changed a whole lot in terms of its composition since those deeds were enforceable, or those restrictive covenants, rather, were enforceable. We know about restrictive covenants. We know about the practices and the policies of the federal government with respect to federal housing programs in the 50s and the 60s. We know about how highways were laid out, who was displaced, how they were displaced in segregated ways. We know all those things now. And yet we still act as if our neighborhoods look the way they do as a consequence of, as I said, serendipity. I talked about the public housing project and the issues that we faced as I was growing up because I want to be candid. You know, it had its problems. It had its pluses, but it had its problems. You get these forces, these conflicts that exist in terms of how people view communities that are populated by people of color, and particularly by African Americans. And then finally you get, in 1968, at the end of the Civil Rights Movement, you get the Fair Housing Act, 1968. I often point out, and bear with me for a minute, I haven't been here for a while, so probably nobody has to say, oh, I've heard this before, hold on. I often point out that we're 3 years away right now from the 400th anniversary of the involuntary introduction of people of African descent in what's now the United States. Now let me correct myself. Everybody in this room is of African descent. But I'm talking about the people who are known now as African Americans. 400 years in 1619 to 2019. For African Americans in what's now the United States, for 335 of those years, we lived, subjugated by law. The either slavery or Jim Crow segregation if we use Brown versus Board of Education as a cutoff point, 1954. That's too generous, because we know it wasn't until 1964 that the Civil Rights Act of 1964 was passed. So up until then, it was legal to discriminate in employment, in public facilities, in federally funded programs, on and on. 1965, the Voting Rights Act. Till 1967, it was illegal in many states to marry interracially. Struck down in Loving versus Virginia in 1967. Think about that. You know, for some people in this room, the few who feel like that's a long time ago, it wasn't. There's a justice on the Supreme Court who was alive then, who would be in criminal violation of law right now in the state in which he lives, because he's in an interracial marriage. Wasn't that long ago. I'm tempted to take a little bit of a sidebar on even that point. And in fact, I will. Bear with me. Bear with me for a moment on this. You might think it's unrelated to housing and neighborhoods, but it's part of this context. So I stand here before you, you look at me, you might say, well, maybe this is the son of an interracial marriage. I'm not. In fact, I've done a lot of genealogical research. It's a wonderful thing that we can do now, those of us who don't take it too seriously. And but sometimes people take it seriously and they have all kinds of expectations and ideas about who and what they are. And they find out that it's not quite what they think, or it's more complicated. That's true for all of us, by the way. But if you get into this stuff, it can be very interesting. So I can't find so far. I'm not saying they're not there. But if so, they're kind of hiding, and maybe there's only one or two of them. I couldn't find any white folks in my family after slavery. Think about that for a minute. You know, when this fellow who was running for Congress, for the Senate rather, from Missouri, trying to get to the Senate from Congress, what was his name? Aiken, I think, a few years ago, made his statement about legitimate rape, that there was some physiological mechanism that women had in their body. If they were raped, it would defend them from getting pregnant. Do you remember that?
Yeah. Oh, yeah.
And so people got upset with him as they should have. But I thought about something I didn't hear anybody say. That there are millions of African Americans whose very countenances today put to the lie to what he said. You follow me? I'm one of them, and many of us. So back to this point about the timeline, which itself you may think is a detour. It's not. So it wasn't until '68, after the assassination of Martin Luther King, of course, that the Fair Housing Act, which had been languishing, was finally enacted. Every major piece of civil rights legislation, certainly in the '60s, but even before that, was bought and paid for in blood. You know, the Civil Rights Act of '64 wasn't enacted until after Kennedy's assassination. The Voting Rights Act, Bloody Sunday. The '68 Fair Housing Act. Dr. King's assassination and the violence that racked American cities. Those of us who have a memory, we can talk about what that looked like when it happened. And then you get this act, which also followed on the heels of the Kerner Commission report, often forgotten these days, that said, among other things, that we are moving toward two societies, one black, one white, separate and unequal. Every time I looked at that, I was curious about where the authors thought we were moving from. But the was only in the aftermath of seasons of violence, urban rebellions or riots, whatever you want to call them, that those statements were made. And there were a whole series of recommendations in the Kerner Commission that addressed a number of subjects, including housing. And the Kerner Commission recommended the passage of anti-discrimination housing legislation, but it didn't happen until after King's assassination. So we really can't stop at 335 years. We have to talk about 350 years of subordination under law, either slavery or Jim Crow segregation. The tendencies to talk about slavery as something that was antiquated. It happened back in the 1800s, ended in 1863, or depending on whether you're talking about the Emancipation Proclamation or the 13th Amendment, 1865. But it was a long time ago, not relevant to us now. But it's wrong to talk about slavery disconnected from Jim Crow segregation, which continued right on up through the 1960s. It was a continuum. And if you do the math, even as we sit here at the Weber Inn this morning, in 2016, 3 years before that 400th anniversary, just about 9 out of every 10 days of the existence of African Americans in what's now the United States has been spent under legal subordination in the form of slavery or Jim Crow segregation. Go home and look at the math and do it, and if you find out that I've miscalculated, you can find me at UNC Chapel Hill Law School and tell me that I'm wrong. Why is all this relevant? Because our discourse today is one of colorblindness, and we say that all of these unpleasantries are no longer relevant. And yet we have this massive inequality that continues in spite of all the tremendous progress. Don't misunderstand me. We've made tremendous progress in this country. But we still have massive inequalities, and the fiction, both in social discourse and in legal discourse, is that those inequalities are now unconnected to that long history. That the inequalities we see now are failures of character. The refusal of some individuals to take advantage of opportunities. Yes, some people do fail to take advantage of opportunities for all kinds of reasons, and I believe in personal responsibility, but personal responsibility has often been used as an instrument of shutting down discourse about the connection between our history and our present. So when I began to do Fair Housing Act litigation, I began to see even in more detail how communities came to look the way they did. And the Fair Housing Act is different from many other statutes because if you look at the Fair Housing Act, it, among other things, as everybody in this room knows, it talked about an affirmative charge to change living patterns in the United States and to create integrated communities. That's different. It was also interpreted, as you know, to include an effects test, a disparate impact test, which is different from the way many of our other statutes, and certainly our Constitution's 14th Amendment, has been interpreted by law. So you had this powerful weapon that was created, this tool, and the beginning of the possibilities of an school desegregation finally began to become a reality in some southern states. Brown, 1954. Another 15 years or so before Brown really began to be enforced with any seriousness. 1971, the Supreme Court decides a case called Swan versus Charlotte Mecklenburg